back to the Cyber Resilience Brief, a Safe Breach podcast. I'm your host, Tova Dvorin, and with me as always is my co-host and favorite offensive cybersecurity engineer, Adrian Culley. Adrian, good to have you back.
To be back with you, Tova, and all our listeners. We've got a very meaty subject today, and one that has shifted under us whilst we were writing this episode.
Indeed. Today we're talking about the EU AI Act. That's Regulation EU 2024/1689. It entered into force in August 2024, and we're now inside 2 weeks of the August 2nd, 2026 deadline. That date looks different than it did even a month ago, because the EU just finished pushing through a set of amendments that defer a large chunk of the obligations everyone had been bracing for. August 2nd is still very much live, but for different reasons that most compliance teams think.
It's the right framing, and it's worth being precise about upfront, because a lot of the guidance still circulating is stale. Some provisions have already been live for over a year. What changed is that the headline compliance cliff most enterprise teams were bracing for, the bulk of the high-risk obligations, has been pushed back over a year. What hasn't moved is the transparency regime and the GPAI enforcement machinery. That's what's actually landing on the 2nd of August 2026.
So let's get the record straight and then get practical. We're going to cover what the EU AI Act actually requires, who it applies to, exactly what has changed in the last 6 weeks, and what the cybersecurity-specific obligations look like, because there are some and they are specific, and what a CISO should concretely do before the 2nd of August. Adrian, let's start at the top. What is the EU AI Act trying to do?
So in the sentence, Tova, it's the EU applying a risk-based regulatory framework to artificial intelligence systems, the same way GDPR applied a risk-based framework to data. The underlying logic is that some AI systems create genuine risks to safety and fundamental rights, and those risks need to be managed, evidenced, and audited, not just declared or attested, as we've recently talked about. What makes it different from any prior AI initiative is that it's binding law with penalties, not guidance or principles. We've been through guidance and principles. This is the thing that actually has enforcement attached.
And as usual with EU regulations, the penalties are significant.
Penalties make GDPR look conservative. Tiers, top tier, which covers prohibited AI practices, things that are banned outright, is up to 35 million euros or 7% of global annual turnover, whichever is higher. 7% is more than GDPR's 4%, obviously. Tier 2, for violations of the high-risk AI obligations, is 15 million, still not to be sniffed at, or 3% of turnover. Tier 3, for providing misleading information to regulators, is 7.5 million, or 1%. A company with 10 billion euros in global revenue is looking at 300 million euros in potential exposure at the second tier. That number should be concentrating minds.
Absolutely. That's a lot of money that could be better spent on lattes. Now let's walk through the timeline, because the phased implementation has genuinely confused a lot of people. They think because the EU AI Act was signed in 2024 that nothing has actually happened yet, but that's not true, is it?
No, the confusion is understandable. It's a phased implementation which was deliberate. The EU is giving organisations time to prepare. But phased doesn't mean not yet. The Act entered into force on the 1st of August 2024. 6 months later, on the 2nd of February 2025, the first real obligations hit. The prohibited practices ban and the AI literacy requirements. Both of those are live right now, have been for over a year. If your organisation was running AI systems that are now prohibited, social scoring, manipulative AI, workplace emotion recognition, biometric categorization based on sensitive characteristics like race or sexual orientation, you're already in violation.
Yikes. And in August 2025, which has also passed by now, the GPAI obligations came in.
Correct. General purpose AI model obligations. August 2nd, 2025. That's the tier covering foundation models, the large language models, the things underpinning most enterprise AI deployments right now. GPT-4 and its successors, Claude, Gemini, Llama, at commercial scale. Any provider placing those models on the EU market since that date has had to comply with documentation, transparency, and copyright requirements from day one. For models already on the market before August 2025, the grace period runs to August 2027. None of that has moved.
And we'll be right back.
So walk us through what actually happens on August 2nd, 2026, because I understand that answer has changed since we first sat down to plan and write this episode.
It has materially. Originally, two things were meant to land on this date. The bulk of the high-risk AI obligations under Articles 9 through 15 and the transparency obligations under Article 50. As of the amendments that just cleared Parliament and Council, only one of those is still on schedule. Article 50 proceeds as planned. If your AI system interacts with humans, you have to disclose that it's AI unless that's already obvious to a reasonably attentive person. If you generate synthetic audio, image, video, or text, it has to be machine-readable labeled. Deployers using emotion recognition or biometric categorization have to notify the people exposed to it. Deep fakes have to be disclosed with carve-outs for evidently artistic or satirical work. All of that is still August the 2nd. What's no longer landing on schedule is the bulk of the high-risk obligations for Annex 3 systems. Those are set to move to December the 2nd, 2027, once the amendments that just cleared Parliament and Council are formally published. What is expected any day now to happen, and separately from all of that, August the 2nd is also when the AI Office's supervisory grace period for GPAI models ends, meaning the Commission's power to actually fine a foundation model provider goes from theoretical to operative on the 2nd of August 2026.
Okay, those are a lot of changes, and that's a genuinely different shape of deadline than the one most compliance teams built their 2026 plans around. But you said that it's set to move. Does that mean it's already locked in?
Nearly, and I want to be precise about it rather than rounding up. The political initiative process is nearly finished. EU Parliament, EU Council, and the final signed act are all done. What's outstanding is the administrative step. Publication in the official journal expected this month, July, with the amendments entering into force 3 days after that. Until that happens, technically, the original schedule is still what's on the books. Practically, I'd personally bet, not that I'm a gambling person, but on it publishing within days rather than weeks. But the classification and requirements work underneath doesn't change either way. So let's cover that properly first, and we'll come back to the full mechanics of how we got here.
And we'll be right back.
I want to spend real time on the high-risk classification because I think a lot of organizations have either assumed they're not in scope or haven't done the classification work to find out. Walk us through how the EU AI Act defines high risk.
So there are two routes into high risk, Tova. Route one is you're an AI component that forms a safety critical part of a product already regulated under EU product safety law. Medical devices, aviation equipment, vehicles, industrial machinery. If your AI goes into those products and the product requires third-party conformity assessment, your AI component is automatically high risk. Route two, and this is the broader category, you're on the Annex 3 list. Annex 3 is a specific catalogue of AI use cases that the regulation identifies as inherently high risk regardless of what product they're in.
And what is on that list?
So, biometric identification and categorization systems, AI safety components in critical infrastructure, energy, water, transport, financial infrastructure, educational and vocational training decisions. Things like who gets admitted to an institution or gets a qualification. Employment decisions, AI used in recruitment, performance evaluation, promotion, task allocation, monitoring of workers, credit scoring, ensuring risk assessment, law enforcement applications, risk assessment of individuals, predictive policing, emotional state detection, migration and asylum decisions, administration of justice. That's Annex 3. If you're using AI in any of those domains, you are high risk and the full compliance burden applies.
Wow. Given what you just said about the omnibus and the breadth that this covers, when does that full compliance burden actually bite?
So for most of Annex 3, the standalone systems we just listed, December the 2nd, 2027, once the amendments are published. For high-risk AI embedded in regulated products under Annex 1, August the 2nd, 2028, on the same condition. But the classification exercise doesn't wait for either of those dates. You need to know now which bucket you're in, because building Article 9 through 15 controls from a standing start in 6 months was never realistic, and it's still not realistic even with an extra year on the calendar.
Now, as usual, there's a common misconception, I think, that if they're in the UK or in the US, you don't have to worry about this. So US listeners in particular, listen up, this applies to you too.
So the Act is extraterritorial. If you're placing AI systems on the EU market, meaning EU-based deployers use your system, or if your AI's outputs affect people in the EU, you're in scope. Full stop. Headquarters location is irrelevant. That means a US-based human resources software vendor whose product is used by a German company to screen job applicants is subject to full Annex 3 high-risk obligations. Commission has made this very clear by design.
Now let's dive into the operational requirements. Even with the runway just extended, what does high-risk compliance actually look like, and why shouldn't people wait?
So Articles 9 through 15 are where the real work sits. Article 9 is a continuous, the magic word again, risk management obligation, not a one-time assessment. You need a documented risk management system that spans the entire life cycle, design, development, deployment, post-market monitoring. It has to identify foreseeable risks to health, safety, and fundamental rights. It has to estimate and evaluate those risks. It has to implement mitigation measures, and it has to loop production feedback into the risk evaluation, which is the requirement that kills the assess once, deploy forget model. Residual risks have to be confirmed as acceptable and reconfirmed as the system evolves.
Well, once again, we've killed shelfware, but that's a significant operational lift for most organizations.
It is, Tova, and the documentation burden under Article 11 reflects that. Technical documentation has to be drawn up before the system goes to market, maintained throughout its life cycle. The documentation has to be sufficient for a regulator to assess whether the system meets the Act's requirements. For providers, meaning the organizations that build or place the system on the market, this is a substantial upfront investment. Deployers, using somebody else's high-risk system, obligations are somewhat lighter, but they still include verifying that they're using the system within the instructions the provider gave, tracking performance, reporting incidents, and applying appropriate technical controls. Employers put their own brand on a system or make substantial modifications to it, actively also become providers.
Now let's talk about Article 12, which is automatic logging.
So Article 12 requires that high-risk AI systems automatically log events during their operation. The purpose is auditability, post-incident analysis, regulatory investigation, evidence that human oversight, again, another magic word, evidence, human oversight was exercised. The logs have to be retained for the appropriate period, defined in the regulations, and be accessible to deployers and competent authorities. Article 14 is the human oversight requirement. The system has to be designed so that human beings can monitor, understand, intervene in, and where necessary, override or shut down the system. That's not just a governance box. It has architectural implications for how you build the system.
And then there's the big one, and that's Article 15. Tell us a little more about that.
So Article 15 is the one I want our listeners to sit with. It's the accuracy, robustness, and cybersecurity requirement. High-risk AI systems have to be designed and developed to achieve appropriate levels of accuracy, robustness, and cybersecurity throughout their life cycle. That's the general standard. Paragraph 5 of Article 15 gets specific. The technical solutions to address AI-specific vulnerabilities must include, where appropriate, measures to prevent, detect, respond to, resolve, and control for attacks trying to manipulate the training data set, that's data poisoning, pre-trained components used in training, model poisoning, inputs designed to cause the AI model to make a mistake, adversarial examples, model evasion, confidentiality attacks, model flaws.
Accuracy, robustness, and cybersecurity, by the way, that means it's the ARC of the EU AI Act. Should definitely go forward with that.
And we'll be right back.
But anyway, if you look overall, this regulation, it names specific attack categories as well, and that's based in some real-time analysis. Let's talk about what that is.
So it does, Tova. Explicitly, in the regulatory text, the EU has essentially looked at the MITRE ATLAS framework, for those who aren't familiar with that, and the OWASP top 10 for LLM applications, and written the threat categories directly into law. So let's just repeat that. We're now seeing for the first time in the world the MITRE ATLAS framework for artificial intelligence systems and the OWASP top 10 for LLM written into law, into legislation. This isn't a soft obligation to consider cybersecurity. It's a mandate to have technical measures against named attack classes and to be able to evidence those measures to a regulator. That changes the compliance question from have we thought about AI security to can we prove our AI system is resilient against these specific attacks? And to be clear, this requirement doesn't disappear because the deadline moved. It's coming December 2027 for Annex 3 systems on the same substance at the same height of bar.
And this extends to GPAI models with systemic risk, which is the tier above standard GPAI and which is untouched by any of what we've just described.
Correct, completely untouched. Providers of GPAI models assessed as presenting systemic risk. The threshold is based on computational power used for training, but it captures the major frontier models, which have additional obligations, including adversarial testing, not just testing, documented adversarial testing, red teaming, attack simulation against the model itself to identify and mitigate systemic risks. And they have to track, document, and report serious incidents to the AI Office and national competent authorities without undue delay. The serious incident definition is broad: death, serious injury, significant disruption of critical infrastructure, significant property damage, infringement of fundamental rights obligations. If an AI system failure causes any of those outcomes, it's reportable. This has been binding since August 2025.
So zooming out a little, this is in some ways the AI equivalent of what NIST 2 does for cybersecurity incidents. Mandatory incident reporting with a defined scope and timelines.
Exactly, Tova. And the intersection between these regimes is real. If you're a financial entity operating under DORA and you have an AI system that qualifies as high risk under the AI Act, that AI system is an ICT asset as defined under DORA, which it probably is, defined under DORA. Then you have three overlapping sets of obligations: DORA's ICT risk management and threat-led penetration testing requirements, NIST 2's risk management and incident reporting requirements, if you're an essential or important entity, and the AI Act's Article 9 through 15 requirements. A single AI incident can now trigger reporting obligations under all three frameworks simultaneously, with different timelines and different regulatory addressees.
Which makes the compliance stack even more complex to navigate.
It does, and the honest observation is that most organizations haven't mapped their AI deployments across all three frameworks yet. They've been thinking about DORA and NIS 2 as cybersecurity regulations, and the AI Act as an AI governance thing. They haven't yet sat down and done the overlap analysis. The regulator doesn't care about that internal separation. If you have an AI-powered fraud detection system, for example, deployed by a European bank, financial entity, it's simultaneously an ICT asset under DORA, a system operated by an essential entity under NIS 2, and very likely an Annex 3 high-risk AI system under the AI Act. Credit and financial risk assessment is on the list. All three regimes apply at once.
Now let's talk about where validation and testing sit in this compliance picture, because the AI Act has a specific testing angle that's different from a traditional cybersecurity compliance posture.
That's the part I think is genuinely underappreciated. Most compliance frameworks treat testing as a point-in-time activity. You do your annual pen test, you go get your report, you file it, you're done until next year. The AI Act explicitly doesn't work that way. Article 9 requires a continuous risk management system, which means ongoing testing as the system changes or as new risks emerge, as your security posture shifts. And the Article 15 obligations, the adversarial example, data poisoning, model evasion requirements, aren't met by checking a box once. They require a demonstration that technical controls hold over time against an evolving threat landscape.
So once again, here's our magic word: continuous. It's not a point-in-time snapshot.
Right. And this is where the adversarial exposure validation model becomes directly relevant to the AI Act. Compliance not as a stretch as the literal mechanism. The defenders I've worked with who are best positioned for this obligation are already running continuous adversarial testing against their AI systems, running adversarial inputs, attempting model evasion, testing data pipeline integrity, exercising the detection and response side. That's not a compliance exercise bolted onto security operations. It's an integrated program where the output is both an operational signal and compliance evidence. Safe breach customers who've extended the discipline to their AI surface are generating the kind of logged, time-stamped validation artifacts and evidence that Article 15 asks for. But the methodology holds regardless of platform. What matters is that you're actually running adversarial tests against your high-risk AI systems and keeping the records. An auditor from a national supervisory authority is going to ask to see those records. We believe our AI is robust is not the answer to that question.
And that connects back to the DORA and NIST 2 triangle we were describing earlier. One validation program that generates evidence for all three frameworks rather than three separate compliance exercises. And this goes back to an episode we just recorded also, CTEM with an E, CTEM, It's evidence.
Which is the efficient way to do it, Tova. 3 regulations, 1 validation discipline, 1 evidence store. The reporting destinations differ. DORA instance go to financial supervisors. NIS2 instance go to the National Cybersecurity Authority. AI Act instance go to the AI Office or National AI Authority. But the underlying testing and validation practice that demonstrates compliance with all 3 is the same activity. Organizations that are in trouble are the ones treating each regulation as a separate compliance project with a separate team and a separate testing cycle. The ones in good shape are running a unified program.
Right. Death of shelfware, death of silos.
And we'll be right back.
Now let's move to what a CISO should actually do. We're 2 weeks past August 2nd as of the time this airs, and the picture is genuinely 2-track now. Some things are due imminently, and others just got a lot more runway. So what is the action list for next week for a CISO listening today?
So 5 things in priority order. First, if you haven't done an AI inventory and risk classification, do it now, not at some point this quarter. Now, you need to know which AI systems you're operating or deploying, whether any fall into the Annex 3 categories or the regulated products route. And, just as importantly right now, whether any of them trigger Article 50's transparency duties, because that's the piece that's still landing on the 2nd, regardless of the high risk delay.
And what's the second priority?
Get your Article 50 disclosures and labeling actually built and tested before the 2nd. Chatbot notices at the right point in the interaction, machine readable marking on synthetic audio, image, video, or text that survives your real publication workflow, not just a demo. Notices for any emotion recognition or biometric categorization system. Deepfake disclosure. If you placed a content generating system on the market before August the 2nd, check whether it qualifies for the narrow watermarking grace period that runs to December the 2nd. But don't assume every Article 50 duty gets that grace period, because it doesn't. The other disclosure duties still land on the 2nd with no cushion.
So it sounds like that second priority requires some homework. What about the next priority?
So for any AI system you've already decided is high risk, get the documentation audit started, but recalibrate the timeline rather than shelving the work. Articles 11 and 12 both require documentation that should, by rights, already exist. Often it doesn't. Technical documentation showing how the system was designed and validated, automatic logging of system events, evidence of the risk management process. The deadline for most of that just moved to December 2027. 16 extra months of real runway, not a reason to stop. Organizations that treat that extra time as cancellation rather than runway will be doing this same work in a much bigger hurry with much less time in 2027.
Now let's talk about GPAI, which I believe is in our 4th priority list here.
If you're using a GPAI model, meaning a foundation model, a large language model, integrated into a high-risk AI system, you need to get the documentation from the model provider now, because this one is unaffected by any of the omnibus changes. Article 53 creates a pass-through obligation. The model provider has to give deployers the documentation they need to understand what they're deploying, and deployers need to obtain and retain that documentation. If you haven't asked your model provider for their AI Act Article 53 compliance package, ask now. If they don't have one, that's a vendor risk conversation, and you need to be having that before the 2nd, because that's when the AI office's fining power over those providers actually switches on.
Okay, I counted 4. What's our final priority out of our 5 priorities that CISO should be doing right now?
So, ongoing work, Tova, build and or review your adversarial testing program and split it into 2 tracks. For GPAI systemic risk models, this is already a live binding obligation with real enforcement teeth arriving on the 2nd. If your organization builds or fine-tunes a model anywhere near that systemic risk threshold, that work needs to be demonstrable now. For your own Annex 3 high-risk systems, Article 15 names data poisoning, evasion, serial examples, confidentiality attacks as the threat classes you need technical measures against. And you now have until December 2027 to prove it, which is exactly why you should start the pilot now rather than waiting until 2027, which, let's be honest, is weeks away. Pick your highest risk AI system, run a structured adversarial test against it, document the methodology and the outcomes. That's your first compliance artifact under Article 15, and it's worth having whether the clock reads 2 weeks or 2 years.
Adrian, thank you so much for filling us in on all of the technical requirements of this EU AI Act, which is a good meaty piece of compliance, whether you're in the EU or outside of the EU. We are going to do a part 2 of this episode, so listeners, stay tuned. We're going to zoom out a little bit more and go into some of the overarching ideas behind this and how it affects you. Now, for our listeners, we're past 2 weeks of August 2nd. If you're not sure where you stand, the priorities Adrian just named are your starting point. Know your AI inventory and classification, get your Article 50 disclosures and labeling tested and ready. Get the high-risk documentation audit moving, even with the extra runway. Chase down your GPAI model provider's Article 53 documentation before the 2nd of August, and build or review your adversarial testing program. We'll link in the show notes to the Article 15 text, the GPAI Code of Practice, and to the AI Act Service Desk, which is the Commission's own guidance portal. As always, thank you for listening to the Cyber Resilience Brief. Until next time, stay safe with Safe Breach.
The Cyber Resilience Brief is a Safe Breach podcast. Executive produced by Adrian Culley and Tova Dvorin. Music produced by Sarah Dressner. Hosted, edited, and compiled on Riverside. For more about Safe Breach and how you can validate your security controls across your entire IT infrastructure, visit us at www.safebreach.com. That's www.safebeach.com.